Dear James, it's my great pleasure talking to you about the recent development of Chinese patent system, especially in the Chem-biofield. As you may know, the Chinese patent system has just found for less than 40 years, and the patent law had been amended 4 times. It all takes 8 years for the first 3 amendments. However, for the last amendments, it takes 12 years, probably because the trade war between US and China this year. And the IP was realized more and more important for China. So a lot of big changes was involved in this amendment, and it was enforced in June the 1st last year. Today, I mainly talk about the following topics: PTA and PTE, punitive damages and open license, national phase of PCT application in China, and other changes and developments. For the first and fourth, just for bio and chem field, and the second and third, they are related to the major changes in common field. PTA and PTE belong to the patent linkage and early settlement mechanism on drug patent disputes, which discussed for quite a long time in China and finally enforced in last July. PTA is for patents granted after 4 years from the application date or 3 years from the date of request for substantive examination. PTA is for compensating the patent term due to the unreasonable delays during prosecution, but it will accept for unreasonable delays caused by the applicant. For example, request of deferred or delayed examination and the restoration of rights, etc. PTA is not limited to the drug patent. Any patent meet the requirement can enjoy it. Since the examination speed of China these years can be quite fast, so PTA probably will mainly apply to those difficult cases or re-examination or divisional cases. However, PTE is for patent of new drugs approved for marketing in China, and the compensation time will not exceed 5 years, and the total remaining term of the patent shall not exceed 14 years from the date the new drug approved for marketing. And about the corresponding implementing regulation of the patent law, I heard it would be implemented on last October. Obviously, it didn't come to ground. It's still a draft for now. According to this draft, the type of patent which can enjoy PTE are limited to the product, preparation method, and medical use related patents of all chemical drugs, bio, and traditional Chinese medicines. The new drug-related patents refers to the patents related to the API of new drugs approved for the first time by the NMPA, which is Chinese FDA. New traditional Chinese medicine patents include patents related to original medicine and improved original medicine with new functions and indications. The calculation method for the PTE compensation time is the date approved for marketing in China minus the patent application date, then minus 5 years. During the compensation time, the protection scope of the patent is limited to the new drug and is limited to the approved indications. When the patentee requests PTE, he shall submit a request within 3 months from the date when the drug marketing authorization application is approved, and the patent should meet the following conditions. If there are multiple patents for a drug, only one of them can be compensated. And if a patent involves multiple drugs, only one drug can be requested for PTE. And the patent master has not yet received the PTE. And the remaining patent term must no less than 6 months. A request for PTE, one should pay the corresponding fees within 3 months from the date of marketing authorization. In recent years, the guideline for patent examination amended quite frequent in China, about once a year. Last year, there is a draft. However, it didn't come to ground either, probably because the implementing regulation of the patent law didn't come to ground. And this Monday, October the 31st, there is another draft for comments, and the due date is December the 15th. There's still a lot of time. So should you have any comments of these guidelines, you can submit it to the CNIPA. However, for the PTE part, the two drafts kept in accordance. About the condition for compensation, the grant date of the patent should be earlier than the marketing authorization approval date, and the patent should be valid at the time of filing PTE request, and the new drug shall fall within the protection scope of patent. They are all basic requirements. And about compensable improved original drugs, they are limited to these classes. First, esters or salts of known API and new indications of known API. Improved vaccine strains of preventive biologics. New indication of therapeutic biologics and the new indication of traditional Chinese medicine. I'd also like to talk a little bit of the patent linkage system using this opportunity. Here shows the website of the Market Drug Patent Platform, which is a Chinese Orange Book. However, since the platform has just run for over a year, the patents registered on it are limited. Below are the 8 types of patents allowed to register in the platform. For chemical drugs, patents of API compounds, composition, and medical use. For traditional Chinese medicine, patents of composition, extract, and medical use. And for biologics, patent of API sequence structure and medical use. And please notice that the patents not eligible for registration is the intermediates, metabolites, crystalline form, manufacturing process and detection method, etc. And about the rules about registration, a marketing authorization holder, which we call it MAH holder, must register the patent information on the platform within 30 days upon obtaining the authorization. And the following information need to be registered: the drug name, dosage form, drug specification, holder name, patent number, title, etc. The registered patent information should be kept up to date, and any changes to the patent information should be updated within 30 days. And for ANDA, patent statement for chemical generic drug are as follows. For paragraph 1 to 3, not much to talk about, similar to international ones. But for paragraph 4, there are two conditions in China. First, the patent should be invalidated. Second, the generic drug doesn't fall within the scope of the patent. The patentee or interested party remonstrate about the statement of P4 shall file an appeal or request an administrative adjudication within 45 days. The generic drug application shall notify the patentee or NDA holder of the statement and the certifying documents. And the certifying documents should include the comparison chart of technical features between generic drug and the related patents. The first chemical generic drug that successfully challenged the drug patent and obtained market approval can enjoy a 12-month market exclusive period. But the market exclusive period shall not exceed the patent term of the challenged drug. The second part, I'd like to talk about the punitive damage and the open license. They are totally new in this amendment of patent laws. In general, the amount of compensation for infringement shall be determined in accordance with the actual loss suffered by the patentee or the benefit. But in the case of willful infringement with serious circumstances, the amount of compensation may be determined between 1 and 5 times the amount determined in accordance with the above methods. And in the case of willful infringement, it refers to where the infringer knowingly copies or infringes in different forms or intentionally covering up the infringement or refusing to take remedial measures or hiding or destroying evidence of infringement. And for the case of serious circumstances, refers to significant economic loss to the patentee or the amount of illegal profits is huge or a serious negative social impact happens. If it's difficult to calculate the compensation, in the part, the court will determine the compensation from RMB 10,000 to 1 million. However, in its amendment, it changes to 30,000 to 5 million, which shows the will of China to fight against infringement. Here is a chart about detailed comparison between general compensatory principle and the punitive principle. To encourage the enforcement of IP in this amendment of patent law, a brand new system of open license is introduced, where the patentee voluntarily states to the patent office in writing that is willing to license any unit or individuals to exploit his patent and specifies the payment method and the standard of the license fees. The patent office shall make an announcement and implement open license of said patent. Here also shows other related matters that are regulated. Okay. The third part, I'd like to talk about the national phase of PCT application in China. In the past, entering the national phase of China invoke priority restoration and increase or correct priorities are not allowed. Well, after this, the amendment, it will become possible. However, these are still in the draft, and we are not sure if it will change when it comes to ground. There's also one minor change. It's about reduction of substantive examination fees. International search report and the international preliminary report of patentability made by Europe, Japan, and Sweden will no longer enjoy reduced substantive examination fees anymore when entering China. Okay, another part is about other changes and developments in this amendment. It includes the grace period involving no loss of novelty. One condition is added. First, when a state emergency or extraordinary circumstances occurs, it is made public for the first time for the purpose of public interest. And this change probably due to the epidemic of coronavirus, actually. Actually, I'm wondering how it changes the world forever. Other minor changes includes the word count for the title of patents. In another field, it shall be no more than 25 characters. In the past, in Chem and biofield, it can be up to 40 characters. However, in this amendment, it is extended to 60 characters. Also, blood pressure measurement are no longer considered as a diagnostic method, which means it is patentable, means it is patentable right now. And also, one condition is added, information processing method, which all steps are conducted by apparatuses like computer. Its direct purpose is not obtaining diagnostic result or healthy condition, which means it is patentable. Also, one good news for application in biofield is that color drawings become possible. Although no formal regulation or announcement, but we can file color drawings in the patent application in biofield right now. There's also one significant change of the guidelines for patent examination is that a new chapter will be added in the guidelines, which is about traditional Chinese medicine. The contents of this chapter is mainly not new for me, but it really helps for the draft and the examination of the patents of traditional Chinese medicine. Due to the time, and I assume you don't have much cases of this kind, so I will skip these slides. If you have any questions, maybe we can talk about it later or afterwards.
Are there many applications about traditional Chinese medicine? Because, we don't have it here, but
it's a big part of in China. There's many many applications in this field. And recently we are encouraging the development of these traditional Chinese medicines. So a new chapter will be added in the guidelines for examination. Last, I'd like to talk about two examination examples about supplementary experimental data. It was added in the guidelines in the year 2020, and it's a hot topic in the field. It shows how examiners will consider supplementary experimental data in China. The first example, the claim request to protect compound A, and the description discloses it has hypotensive effect, but didn't disclose the experimental result data. And the applicants supplemented the data on the hypotensive effect of compound A during the substantive examination. The examiner will thus acknowledge it as sufficient disclosure, and this example shows that insufficient disclosure can be overcome by supplementary experimental data. And the second example, the claim request to protect the compound of general formula 1, and the specification discloses multiple specific compounds, A, B, etc., and also record the anti-tumor effect of the general formula. The therapeutic result data was recorded as the IC50 value of the example compounds to tumor cells in the range of 10 to 100 nm. In order to prove the inventiveness of the claim, the applicants supplemented the comparative experimental data, showing that the IC50 value of compound A was 15 nm, while the compound of comparative document 1 was 87 nm. And this shows, and this example shows that the supplementary experimental data can also help in the examination of the inventive step. That's all my PPT. Thank you for hearing.
Yeah, thank you very much.
Yeah,
quite some changes, right, in the Chinese patent
yes,
law. So.
Yes. There's also a lot of changes in the guidelines for patent examination in this version. It was in the October the 21st. It was in the October the 31st. October the 31st. And the due date of the comments is December the 15th. So we can still have a lot of time to go through it. And if you have any comments, you can file it to CNIPA. It involves a lot of changes. And if you are interested, we can send this draft to you. But it's in Chinese version.
Okay. So do you have comments that you would submit to these guidelines?
Not yet. It involves so many things. There's it has 169 pages. It's a lot of things to go through.
Your camera.
Okay. And regarding this infringement damages, is this a big change in the Chinese law? Because I don't know how it was handled before.
You mean the damages?
Yeah, how the damages are calculated.
We have, sorry, let me see. We have three methods. The actual loss suffered by the patent holder due to the infringement, or the benefit obtained by the infringer due to infringement, or the multiples of the license fees. That is the three methods to calculate the damage. But if all these three methods is difficult, but if it is difficult to determine the loss of the right holder, the illegal profits obtained by the infringer and the patent license fee, and then the court will determine the that compensation from RMB 30,000 to 5 million.
Okay. So it's a limit in the damage. I think in Germany there's no limit, no limitation.
But, yes, it's limited, but in the past the number is smaller. In the past, it's from 10,000 to 1 million.